When you're facing a dispute, whether as a project owner, a general contractor, or a subcontractor, your first step should always be to issue a demand letter. That comes after, perhaps obviously, reviewing the file to make sure that you're in the right, or you believe you're in the right, in terms of the party having obligations they've not met, whether that's performance or payment. That demand letter should, with some specificity, lay out what the issue is. You've not paid my invoices timely. You've not showed up to work and adequately staffed your project. You haven't adequately provided the materials that are necessary for me to do the work. You've not unlocked the premises. You've not accepted my deliveries. Whatever that issue is, get it in writing, get it sent in a way that you can confirm a date. That's going to become critical if this thing escalates to the next level. Liens are legal claims and they have certain statutory requirements. So what exactly you need to do next is going to vary a little bit based on the level of contractor you are. That is, whether you have direct, what we call contractual privity, meaning you have a contract with the project owner, or is your contract with the general contractor or a subcontractor? Are you a supplier to one of them? That layer of where you fit into the system is going to fundamentally affect what you need to do to what we call perfect your lien right. The next step is you need to send these notices out to the appropriate people, and there are statutory requirements as to when those things need to be. Those things are researchable online, but it's best to consult with a lawyer to figure out whether you're looking at the right set that apply to you in your particular situation. Because the other part that can vary quite a bit is considering which type of project you're dealing with. A public works project is different from a commercial project, which is different from, say, a residential homestead project. All of them trigger different rights, different notices, different obligations. Be clear on that when you're looking at lien rights. Don't try a one-size-fits-all approach there. Finally, we find yourself at the stage where you have issued all of the notices you're going to issue. You have evaluated and filed, perfected and filed the appropriate liens. Your next step is the last step, hopefully, which is litigation. Litigation is going to require that you engage counsel. You're going to have to file a lawsuit or file an answer to a lawsuit in the appropriate court. And you're going to have to take some major steps in order to perfect your position. Oftentimes, construction cases in particular are going to require that one party or both parties retain the appropriate experts to talk about industry standards, to talk about whether or not something was done properly. You're also going to need economic experts to help us determine what's the actual bottom line effect of someone failing to do A, B, or C, failing to pay on time, failing to perform on time, failing to make the site ready on time. What should someone else have done? If a subcontractor fails to perform by a certain period, what are the general contractor's obligations to try to what we call mitigate that problem? Meaning you can't just sit there and let the problem get worse. What obligations do you have to try to make it better? Those kinds of things are going to require testimony from experts and from witnesses. Securing all of those things is part of the litigation process. A mechanic's lien, or more formally a mechanic and materialman's lien, sometimes called an M&M lien, is fundamentally just a hold against a piece of real property. And when I say hold, what that means is the parties can't buy or sell the property without making the holder of the lien happy. Effectively, from a practical perspective, what this means is that the lien holder gets paid before the seller gets paid. This can create a cascade of problems for a project, especially a commercial project. Banks will get leery. All of a sudden, you've got someone else wanting to get paid at or before at the same time that they get paid. That makes a bank nervous if the property is their collateral. It can make selling that property difficult because someone may not want to take a property with a lien. They may see it as distressed. So all of these things have the effect of making the person who has the title to the property want to make sure that the property is free and clear of liens. That's why it's a valuable tool for a subcontractor or supplier who's not being paid by a general contractor. Merely sending the appropriate notices to the project owner, to the general contractor, and oftentimes is enough to make sure that you as a subcontractor or a supplier moved up the priority chain and paid. If you're a property owner or if you're acquiring property, one of the things you're probably wondering about is, well, how do I remove these liens that are on the title to my property? First step, contact an attorney. Any commercial, especially a commercial property attorney who's familiar with these things, will be able to start to apply the appropriate pressure. It's going to be a question of taking a look at your rights and obligations as a property owner. It's going to be taking a look at whether or not the lien was appropriately filed and can be extinguished in the first place. And it'll fundamentally be an issue of negotiation once all that's figured out. Most lien claims do not result in what we call the nuclear option, which would be forcing the sale of the property. That almost never happens in any major market. What usually happens is someone agrees to pay all or some of that debt in order for the lien to be removed. So even if there's a question over the quality of the work, or there's a question of a counterclaim, there's a question of other issues, those tend to get resolved because of the pressure point of the lien. Nothing can really happen with the liens there. You can't get it refinanced or sold. And having the ability to go to the general contractor or to the subcontractor and say, look, you've got issues too, let's agree on a number, otherwise we're going to bring these things to light. It'll be longer for you to get paid, it'll be longer for me to get my property dealt with, and no one will be happy. There's an opportunity there with the experienced counsel to apply the appropriate pressure and get a deal done. If you're dealing with any of these issues or need any further assistance, don't hesitate to reach out to us here at the Sul Lee Law Firm. We're here to help you navigate complex situations. Thanks for watching, and we'll see you in the next video.